Hi, everyone, and welcome. It's Adam with Intelligo Networks, and today we're going to be going through a nice webinar talk about breach notification myths. We're going to take a look at breach notification requirements. We're going to take a look at some of the misconceptions about how to host your data and where enforcement laws do or don't apply, and talk about the fining culture, what we've got in terms of monetary remuneration for these types of things, and try to get some answers by allowing you guys an AMA at the end of the talk here to ask me any questions about breaches that you think you'd want to know. I'm going to give a couple people an opportunity to join the webinar shortly. So we've got, maybe 60 seconds here before I'll launch into the presentation, and then we'll try to keep it to 30 minutes or just thereabouts, so we can save some time for questions near the end. If you don't see anything, specific, or you need more of a follow-up on anything that I commented on today, feel free to go to intelligonetworks.com and just use the contact us link. We've got a lot of wonderful materials that we're going to try to circulate for the people who registered for this webinar. We want to be able to share those with you. So, if we don't give you a link, or you forget a link somewhere in the presentation, or it's not accessible in the video, just reach out to the contact us and just say, hey, that kit or that thing that you talked about, do you have one of those? I was hoping to get them for a friend or myself. Take a couple more minutes while we're doing that, or sorry, just one more minute while we're doing that. I'll just briefly intro this talk series. Our last talk series was about CIO budgeting, how to build a budget for cybersecurity. Follow up to this talk about breach notification is going to be an actual panel where we're going to be talking to an actual customer that had one of their partners breached and how they dealt with it, what kinds of things they had to go through to notify of a breach, and that's coming up in a couple weeks. So stay tuned for that. We'll have another promo for that webinar after this. And again, if you have any topics or suggestions for us, feel free to reach out again on our contact us or LinkedIn page and let us know what kind of things you'd like us to talk about as well. All right, I'm going to jump right into it here. I'm going to share my screen, and we are going to get into it right now. So today's topic, breach notification, myths busted. There's a lot of different types of information floating around, different types of expectations, depending on different types of breaches that customers have experienced. They may be sort of unsure whether or not there's notification requirements for the data involved, for the people involved, and what kind of things to do that. So what we want to do is just give you a chance to discuss this at the end of this and try to bring you up to speed on some of the changes with respect to privacy regulations. So my name is Adam Mansour. I operate as a virtual CISO. Today's session is going to be talking about privacy and compliance with privacy regulations. We're going to do a type of live exercise where we talk about should you disclose, give you a couple of different scenarios, and I'll share sort of my experience as to whether or not you should or shouldn't disclose to the user or to a privacy office that breach. The AMA should give you an opportunity to ask me any questions. And what we're hoping to do is give you guys the kind of resources that'll help you do this in real life. So we've got a disclosure Rolodex we'll be rolling out for everyone. It's a list of all the different privacy offices in North America and Europe that will allow you to simplify the process of getting in touch with those privacy offices during a breach notification, as well as a nice toolkit that includes the notification templates, a nice letter, and an incident response setup that will help you sort of qualify this for yourself. So let's go through this. Losing data could cost you $17 million, right? And you hear these sort of huge fines coming out. In this case, what I'm referencing is, a potential data loss that happened when a OSAP loans in Ontario, Canada, lost a USB key, and the liability from that was a $17 million class action suit. You could also spend that money on Taylor Swift's mansion on the left. So we want to make sure that you can save your money for fun things like, buying software or potentially mansions on a hill in Rhode Island, as opposed to, simply owing your customers money for losing their data. Quick disclaimer, I'm not a lawyer. This isn't legal advice. It is for IT professionals in an IT context to bring them up to speed. So the scope of our discussion is going to be to enable IT managers to understand how to properly disclose a privacy breach, specifically with PII. The summary of the regulations talked about in our talk are going to be specific to the EU, USA, and Canada. There's a lot of other regulatory changes for different areas of Asia and Africa America and things like that. We're going to focus on EU, EEA member states, USA states, and Canadian provinces. We're also going to try to clear up some misconceptions, right? There's a lot of different information floating around, different articles written that people tend to take as gospel. And so we're going to talk about how privacy fines are enforced, right? When you actually have to pay these types of things. Some confusion about extraterritorial rules. Can one country give a fine to another one? And data residency. People think a lot about hosting in country and regulations that, they believe they have to follow to host data within their own home country. So we're going to talk about when and how you have to do that. First, we're just going to jump through a quick example, make sure that everybody's engaged here. So in the chat, what I'd love to do is just have you guys type out the multiple choice answer that you think is the right thing to do for this particular scenario. Let's assume that you're on a trade show and your the trade show setup team ends up losing a laptop, right? So you lose a laptop somewhere in a hotel or on a company trip. The employee tries to get the laptop back, and after a few days contacts IT and says, hey, I need a new laptop, I lost it, I'm sorry. And the desktop admin comes to you as the director of IT or manager of IT and says, hey, by the way, we lost this laptop, I think it's a security breach, and we've got a number of company emails for internal staff and some names collected from the trade show on that device, but we do also have the hardware encrypted. Right. So, we don't think people can get access to that information. So in this case, it'd be good to know what you guys think. We're going to cover more of these later in the talk, but do you think you should report this to A, nobody, and just record it in a breach notification registry? B, do you think you should notify the privacy office? C, do you think you should notify the actual users whose information was lost? Or do you think it is D, to notify both the privacy office and the end user? And we're going to have you guys type in your chat, and when we get to the other scenarios, I'll review those answers and see how many people sort of thought it was A, B, C, or D. But let's just run through very quickly a history of privacy fines in the private sector. It's important to understand that if you're a private company that is not publicly traded, right, you could still be publicly traded, but private in the sense that you are a non-government entity. You operate in North America or Europe. Your privacy fines and issues with respect to breach notification date back probably as early as 1996 with HIPAA, when healthcare institutions wanted the ability to transfer health data. So the Health Information Portability and Accountability Act set up a set of regulatory rules on how your information needs to be protected to help it move, as well as fines for people who did not protect it sufficiently and ended up losing it. As time went on, this type of regulatory things were set up for different data types. We had some PCI DSS in 2006 talking about credit card data, and more recently with much steeper fines. You see things like the General Data Protection Regulation in the EU and different privacy fines showing up for things like CCPA in the US or Bill 64 over in Quebec in Canada. Now, it's important to understand that the types of data and where the regions are is what affects these regulations. They happen to be now in specific provinces and states, and we're going to walk through exactly how those PII fines might apply to your organization. But first, let's level set. What specifically is PII, right? It's anything that can identify you as an individual or a person as an individual. So if you can single somebody out, this could be anything from full face photos, biometrics, geographic information, such as their whereabouts on their cell phone, information like their address, their phone number, license plate, SIM card, other types of things that belong specifically to them. Right? And we want to know about a specific type of event. When are we breached, right? When is there a breach classified? Well, breaches are really when somebody else other than the intended collector of that information, mainly your company, has access to the information, right? You lose a laptop or some outside software attack happens and there's an unauthorized third party that basically gets access to that information, or you lose something. Now, it's important to understand that when you have a breach, there's also an obligation in some cases as to when you should notify, right? So there's PII, there's breaches, and then there's a decision you have to make as to whether or not you should notify. And, on the average, what we sort of say is you have to believe that there is significant harm, right? Which could include things like bodily harm, financial loss of employment or professional opportunities, financial loss. And we're going to get into a few scenarios about when IT needs to make the decision as to when to notify, because it is still, not a carte blanche case where any unauthorized access to PII information immediately means disclosure. There are different scenarios as to when you wouldn't disclose to the user or to a privacy office. But let's talk about the privacy regulations themselves, which dictate this type of thing. In the Canadian experience, you're going to see a federal regulation called PIPEDA, right? You'll also see the Privacy Act that applies to the public sector or government institutions. You'll also be able to take a province to province, regulatory information there. And again, you should probably take a look at the slides if you're squinting to see what these acronyms are for each province. But again, we also have a nice, artifact at the end, which is a link to each of the sites and their breach notification rules and forms. So you can essentially have that all collected for you. So don't worry about taking notes just yet. In the USA, we've got about 46 states, likely more, that are going to be coming on with their own individual privacy regulations. Those happen at the state level. And of course, the big, well-known, very well-marketed GDPR in EU EEA member states that applies to countries and EEA members that are part of the European Union, known as the General Data Protection Regulation, live in May 25th of 2018. So that's kind of the background on where privacy regulations apply. And again, I know the scope of this discussion is just to North America and Europe, but that's basically where they come in. And of course, I'm excluding Mexico in there as well. Let's talk about how privacy fines are enforced. Privacy fines have been enforced shortly after the regulation would take action, right? So they'll basically table a bunch of these things. They'll tell you the drop dead date of when these rules are enforced, and usually they'll try to give enough of their citizens and private companies an opportunity to get ready for these types of things. In the case of GDPR, that date was May 25th of 2018, and as you look at the timelines here, the bottom graph here, costs versus date, you can start to see how the fines began to become enforced. Shortly after January, you start to see a fairly large uptick in the actual payments coming in for the fines that were distributed to other companies. And you see that sort of skyrocketing, later in the summer of that year and continuing to increase. So while we don't see as dramatic an increase, we're starting to see more frequent fines, right? So if you look to the right, fine frequency, fines versus date, you'll see that, we're starting to have a pretty, consistent number of fines sort of grow. It's almost like a simple linear curve there. What that really means is that, they're handing out more fines. The fines are, pretty steep. They can be anywhere from 17 million euros to, several percentage points of your actual revenue, which is where the lion's share of this data comes in. And one important thing to remember about this is that while there's no specific technical controls that GDPR tries to enforce, if you look at the reasons for the fine, you'll see that insufficient technical and organizational measures to ensure protection is part of it. So when you talk about technical measures, it's a little gray, but basically you didn't protect the information with encryption, you didn't have a process for going through and notifying correctly, and as a result, things like breach notification obligations or insufficient technical controls can be the reason that the ICO fines you, the Information Commissioner's Office. Now, that's all well and good. Let's talk about the USA, because most people think that when you think about privacy fines, that there is no governing body or nobody going out and protecting your information and collecting fines on that behalf. Now, when you go through and look at the individual fines, there's a lot that's coming out of the Federal Trade Commission that is related to privacy fines. So you'll see companies like Facebook and Equifax, YouTube, Apple, fairly large companies, paying fairly steep fines. They're much higher in terms of the fine totals as the European Union, right? In total for GDPR fines, for example, you're up to about 500 million euros, or almost $500 million, whereas in the US, it's well above that, right? You're closer to roughly 6 billion. And of course, there are some outliers here, Facebook and Google, getting the lion's share of these types of privacy fines because they have a lot of personally identifiable information, and the Federal Trade Commission thinks they're using that unfairly for anti-competitive practice. But they are, of course, far and away the leader. Now, you are going to see some changes in the USA. You have, of course, the California Consumer Privacy Act in California. You have NYDFS for financially regulated private institutions in New York. And so you're going to start to see individual smaller companies likely pay smaller fines, but they're going to start to come up state to state, right? Canada also has a very diverse set of regulatory bodies that enforce privacy fines, right? They have a privacy office, they have the Privacy Commissioner of Canada, they have individual privacy offices for each province, and they are collecting statistics from companies that have breaches, ransomware, different types of accidental disclosure, and they'll put those statistics up on their website. So they've had about 680 since publishing those regulations, breach notifications to that office. But that's not where the fines necessarily come from in Canada. You have, anti-competition regulation for things like Facebook collecting private information about citizens without disclosure or without, proper consent. And that ends up being one of the largest types of fines that you can get in Canada, right? So you'll have, trade commissions issuing fines of up to 9 million in Facebook's case and other smaller ones for different types of anti-competitive acts. You also see things like Castle's, the anti-spam regulation, handing out a number of different fines. An example of that would be the data blocks fine, which was fined up to $250,000 for collecting information about people and using it to email them without their consent. You also have a number of different Castle violations, probably up to 1.2 million, so certainly not as high as the USA or the EU. And we're going to talk about extraterritorial fines very shortly, because it's important to understand that regulations and violations that happen in Canada of EU regulations are also something where it's sometimes a little bit of FUD, right? Fear, uncertainty, and doubt about how those things actually play out. So we're going to go through a very quick example here and answer the question: can a regulator fine me if they're in another country? If I don't have a business or personnel or employees in that country, can they actually issue me a fine that I have to pay with respect to their own regulation? And Aggregate IQ is probably the single greatest case study in this, because it was such a high-profile case where you had a vote to leave Brexit in the EU. So you had a company called SLC that had two companies underneath it. One called Cambridge Analytica, which a lot of people might remember from the news and different articles at the time about GDPR regulations and fines and the Brexit vote specifically. But then you also had this other firm called Aggregate IQ that was in Victoria, British Columbia, Canada, right? Who also was collecting a number of, pieces of information about individuals, and of course, later targeting those individuals with specific ads in Facebook's custom audience feature that allowed them to send them very specific, ads targeting them and swaying opinion. Now, GDPR somewhere around May 25th, 2018, went into action, of course, creating new financial penalties for fines. That was, of course, in the EU, and then they sent Aggregate IQ or AIQ a notice, their first notice, and that was in a few months after the regulation came into enforcement. So the Information Commissioner's Office, also known as the ICO, sent a note to Aggregate IQ saying, hey, by the way, delete all of the processing of any information you have on EU or UK citizens right now. And then, several days after that, 30 days after that, you had them send a breach notice specifically to them saying, okay, you violated the regulation. You now owe 20 million euros as a fine. And independently, the Privacy Commissioner was also of BC investigating them for breaches of that regulation. And so the story culminates and ends in 2019 with the BC Privacy Commissioner finding that they did violate the laws but couldn't collect financial penalties. So the EU didn't get a check from this firm, and neither does the BC government or the Treasury there in BC. Good example of how, while they've issued the notices and there are financial penalties stated on the website, you have a number of ways in which this can play out that mean that you're not paying extraterritorial fines. Now, this might have been very different if Aggregate IQ had offices in the UK or were filing UK taxes or something like that. Unfortunately, they were localized to the EU, which talks about how data residency can apply. Which brings us to another point, which is, if these regulations apply and your citizen data can apply, can you force companies to host your data in country? And this was something that changed fairly recently. It used to be that pre-NAFTA, the North American Free Trade Agreement between USA, Mexico, and Canada, used to have specific export restrictions on different types of data, right? This, famously included things like financial and tax information. So if you were a, Canadian financial institution, it used to be part of the regulation. You said, okay, well, you have to leave certain types of data in your country. One of the goals that USSTR set up during the renegotiation of NAFTA in August of last year was that they wanted to make make sure that you had a little bit more free and open capability to buy things like hosting services or other technology services between the USA, Canada, and Mexico. As a result, the USMCA, USA, Mexico, and Canada agreement was set in stone that changed a lot of the regulations about what forced you to keep things in country. So financial and tax information can no longer be kept in country. So you should be able to choose, if you're a financial institution, where you can host your data, both in the USA, Mexico, and Canada, to obviously open up free trade a little bit more there. There are also some stipulations. It's a little bit gray, but they also have a couple of protections still for things like healthcare information or classified information or information such as attorney-client privilege, right? Legal information. So you can still set up RFPs, proposals, stipulations on your business partners to keep certain types of information such as healthcare or legal or classified information in government. There's also, some very interesting ways that the agreement tends to pressure. You see a sentence at the bottom here, trying to guarantee that enforceable consumer protections, including privacy and unsolicited communications, apply to the digital marketplace. And what that really is interpreted to mean is that if there is a privacy regulation or a regulation in the country that you're doing business with, that their data that you're hosting should still have you apply those protections. So, and a very interesting one is castles. And I'll just briefly talk about how the fact that you have an opt-in regulation in Canada and an opt-out regulation in the USA. So if you're sending emails from the USA to Canadian citizens, you look at USMCA and it's trying to say, well, you should probably respect the country of origins regulatory tools like castles, which is very different, where you need consent upfront to send people emails in Canada, and you don't need consent to send them upfront information in the USA. You can just force them to opt out. Now, that's all well and good. I talked about a lot. Let's talk about some quick hard and fast rules, right? The first thing you should educate yourself to do is to make sure that you can go through breach notification. Why? Because it's one of the ways in which the ICOs or different bodies can be alerted to the fact that you've had a data breach, and mishandling a breach can be a reason that you're found culpable in not following the regulation. So following the breach notification process is one of the first and best places to start when trying to deal with regulations like this. Second, there are PII safeguards that are specific to country, state, and province. However, it's better to protect yourself against the worst case regulation. In this case, Gdpr, the longest and most exacting of all the standards. Why? Because while there is a jurisdiction protection right now where fines that are handed out from the EU, if you don't have a business office there, can't necessarily be paid, you're starting to see a culture where they're starting to encourage people to follow the data regulations of the other countries, right? So this probably won't be around forever, and I'm betting that in a year or two, this is definitely going to disappear. B, when you look at the rules that are actually happening throughout different states and provinces, they mirror the GDPR. So following one standard typically gets you away with following other ones that are sort of copycats of that regulation. And while that's not a hard and fast and exact rule, it's becoming more and more common that what they're really doing is building mini GDPRs out of state and provincial regulation. It's also easier to describe individual compliance when you map to a subset. So it's easier to say, look, we did GDPR and we map it to the rest than trying to do them all at one time. Now, we're going to obviously keep one more thing in mind, and that is that you should probably talk to a CISO or talk to legal when you have an issue. And that is because there's a lot of fear, uncertainty, and doubt from IT. They're not experts in this field. And when they get asked or pressured by a customer or auditor, they can sometimes misrepresent their own security posture or their own following of these rules to make sure that they don't say things that are incorrect and open themselves up to potential contract losses and things like that when they don't have to. So let's go through an exercise. I'm just going to take a quick stop here on the sharing. We're going to look at the answers to the first one, and we're going to talk through it there. Can you guys still see me? I'm going to just jump into the chat here. Okay, so we got a lot of B's. We got some D's. That's good. So we have B and D. I just got to remind myself of what B and D they were to notify the privacy office or to notify the user and the privacy office. And this is a good default stance to have for sure. You want to probably, CYA, but sending the privacy office and your users, different types of things when there's not significant harm can alarm them inappropriately, right? You want to notify people that they should protect themselves when there is the risk of significant harm. And if you look at the case, what it says is that the desktop administration team believes that there's company emails, specific emails internal to the company, and some names on that device, but that the device was encrypted. So there's not a very significant question whether they are at immediate and impending risk from this loss. So I would say that it's likely better to just record the incident in the internals, go with step A, not notify the privacy office, which would have to understand why they're at risk and how they're at risk and what kinds of things they have. So if we're not prepared to tell the privacy office specifically why those citizens are at risk and very specifically, what kinds of things they should do to protect themselves, because there likely isn't any. If it's just email addresses, an increased risk of spam is not a real significant likely fallout if the disk was encrypted. So likely I would suggest going with step A, even though it's a pretty good stance to default to B and D. All right, we're going to go through another example here very quickly, and then I'll get into the AMAs. I see a bunch of questions coming in, so I want to make sure I have a chance to answer those. But let's talk about our next one. Ransomware. This is a very good opportunity for people to understand what unauthorized access really is. Let's say you come into your server room one day, you fire up a KVM and you see a encryption message saying, you owe me Bitcoin to get your server back. Let's also assume that you've got a file server that essentially is one of the ones that was encrypted, and it's got a number of invoicing details specific to each client with contact details, letterhead, and things of that nature on that set of files. So in this case, are we going to go with not notifying anybody, notifying the user, notifying the privacy office, or notifying both? I'll give you guys a couple of seconds here just to quickly, send in some chat responses and talk through some of the typical things that occur here. It's important to understand how ransomware happens, right? And one of the key things here is, does ransomware actually mean unauthorized access? And without an MDR provider or EDR or something that's going to tell you very specifically how that process, that executable, actually went and got on the server and how it touched the files or encrypted them, the program touched it, but you don't necessarily know what the program may have done before or after it encrypted the file, right? So it's very good to get the right information from these types of tools. That's kind of why MDR can help you in this particular case. But if you look at the access specifically, and you can prove that the executable just got there, it didn't delete or copy or exfiltrate any of the files, that there was no Trojan that gave the person access to the machine, then likely you don't have unauthorized access and you don't have to disclose. But in this case, you have to assume, if you don't have those types of pieces of information, if this is all the information you have, then you likely are notifying both the user and the privacy office of this type of a breach, because ransomware typically is distributed through Trojans, and Trojans are remote access from an unauthorized party. The password protecting of the folders, especially if the file was encrypted, also means that they had administrative access to the machine, meaning they had enough access to get the information specifically. So yeah, I would say D for this particular one. Next, let's talk about partial protections, right? There was a good case example where, a bank in the USA had lost a backup tape and it had credit card information on it, and they owed $850,000 in a suit that was filed after for their mishandling of that data. Now, when you look at this, if this applied to you, when would it apply to you, right? So we'll talk about partial protections. What if you had a database with customer information on it, such as names, addresses, phone numbers, and you also had social insurance and credit card billing information in that database? But you had the database components encrypted. The credit card and the social insurance number was very well protected so that it could only be accessed on the server. But you lost the backup tape with the encrypted copy of those two fields, but the rest of the fields were open. In this case, would you notify the user and the privacy office, the user, or privacy office and the user? And this is another great example of how, our next webinar will talk about whether partial protections on the information were good enough. It really depends what happened to the data in this case. If it was lost on a tape and you can't decide where it went, or how it's going to who it's going to, then probably the information on that tape, even if two of the fields are encrypted, likely put the person at significant harm, because now you have a way that information could be removed, and a large database of other factors that will allow you to do things like, impersonate their identity and everything else. So this would be another great example of D. Let's talk about circumstantial sensitivity. When is information sensitive and when is it not? And this is a great example on the GDPR website itself, where the type of information is important, but how it's actually disclosed to third parties is also important. Just give me a sec here. I just need to make sure that I might extend the time. Okay, we're still going. So in this example, let's say that you lose information about a person's name and you're an adoption agency who accidentally sent birth parents to adopted parents. This is a great example of significant harm, right? So the name and address of somebody is not exactly significant harm, but when you send it to somebody who might harass them or send them threatening calls or in some way, give them loss of opportunities, maybe they had to move because the people now know where they are and are trying to come to the house. This is a great example, and this is used by the I code to define what significant harm is because the information itself, it doesn't indicate it, but how the information was disclosed for sure would put somebody's reputation or their relationships at risk. So, privacy office and user in this case are a great example of when you'd want to notify, right? Examples of the Ashley Madison breach, where people are having extramarital affairs that can obviously, affect their relationship, so that you'd also want to notify there, in examples like that. But what if the same information or the same disclosure, right? So you still, lose some data on a USB key, very similar to the previous example, but it's just email addresses and full names, but it's a lot of users, right? But you're a marketing company, right? If it's just email addresses and names, even though it's PII, you're not going to likely have a very significant risk. In this case, you may want to just do B and not the users. You may want to take guidance from the privacy office to see what they say. So this is an example of when significant harm could or couldn't happen. Maybe they'll get spammed. Maybe there's some other information about them that you don't want to understand because let's say they're the aggregate IQ database. Maybe it's a voter database, right? Who knows, right? So as a marketing company, that's kind of a generic term to say, what are you doing with this information? How are you targeting people? How is it being used? In this case, I would go to the privacy office and take guidance from them because they can let you off the hook and say, how did you handle it? What else did you do? Did you notify the people? And see if they recommend doing that. So just to recap, we're going to go through this very quickly, and then we'll open it up for AMA. One of the things we talked about, of course, are fines enforced? Yes, they are. They're enforced by the country, state, and province in which you do business in. And each province and state and EU member, which generally has the general data protection for all those states, will have different regulations that tell you how that fine could be applied, right? Not every regulation has a fine. Not all of them are essentially following the same disclosure practices. So we've created a kit to help you identify which ones do and which ones don't require notification, and they'll let you know if there's other fines there. Extraterritorial or countries fining other countries may be able to happen, right? We've got examples that say that it can't, but you'll see a lot of other fines that are coming out of things like trade commissions and things like that are holding, let's say, American companies responsible for privacy regulation that doesn't have a gray area. So sometimes the EU bungled the one in the aggregate IQ case, so they didn't get any money, and neither did the BC office. But that's not to say that others, like the FTC or other trade commissions haven't tried out. You also have, data residency, right? That's not always going to protect you. Those rules are sort of getting blurred with USMCA. So for financial institutions, for example, you now have to give people the opportunity to bid on your contracts or get special permission from places like OSFI, the Superintendent of Financial Institutions, to try to get, your workaround there. If you want to say my data residency is what's going to protect me, my country rules and my country data is what protects me from other people being able to see it or look at it. What you should do if you lose a USB key, or potential breach is prepare for the worst case scenario with GDPR, walk through this kind of thing, look at services like MDR, look at services like vCISO as part of MDR, and see if that is something that can help you. Just give me one moment here. So from a preparation perspective, MDR can help you understand what happened in a particular cyber breach or what access certain types of processes had to information, and let you know whether or not you do need to disclose. It'll give you deeper information about whether or not something did or didn't happen, so you don't have to assume the worst and disclose. vCISOs can help you determine who and how to notify. The toolkit here can also help you with that. So we'll have a number of different links for you guys about disclosure that will help you simplify that process so that you not only have a template on how to send the message to your users in the privacy office, but a different set of links to different privacy offices. You can also use the Elite SMB IR Guide, which we developed as another free resource for you to start cataloging how and when you could be breached. So you have these letters ready, you have these offices ready, you have everything ready to go, so you can just sort of follow a script when something like this happens. Tune in next time. We're going to talk about a real security breach, the Blackbaud security breach. We're going to try to get an actual client that was affected by this breach of theirs, walk through how they were notified of the breach, how they dealt with it, have a live panel discussion where we can get even more questions about real life incidents here. So that's something that I think would help sort of shore this up in terms of the resources we're providing and the kinds of tools that the Blackbaud could have used, or their tools could have been using. Their customers could have been using to help themselves in that breach. All right, going to stop sharing the screen. Going to jump into specific questions now. I see very similar B's and D's to some of the answers there. So of course, protecting yourself, very good. What are the primary metrics, KPIs a leader should be sharing with stakeholders? How are those metrics, KPIs obtained, e.g. a SIM? I mean, metrics are good to try to tell you that you have a breach, right? Something's got to set off the fire alarm. So there's going to have to be some kind of KPIs, key performance indicator, some kind of metric that tells you whether or not you've had an incident, right? Has that incident turned into a breach? Are the incidents to breaches, are the ratios of how we're investigating these things in there? Many of these regulatory fines are going to talk about custodianship of data. So one of the metrics with respect to privacy, the retention periods, the systems that have access to it, they're all going to be part of there. But I think that the key metrics here are whether or not you could articulate specifically what kind of access the unauthorized parties may have had to systems and data. Right, that's a very important metric, a very important output that you're going to need to know. Because if you don't have a fire alarm telling you about the breach, it's going to be very hard to even know that something like this happened, right? And when you have something like ransomware, which is a really late stage attack, and you don't know specifics about how that particular process accessed stuff, you're just open to full disclosure without really a good understanding of whether or not it was bad. Again, assuming that the data that they accessed and the system that they accessed would put people at significant harm if it was accessed. If they just grab some server that was used to build toothpicks and there's nothing sensitive in there, then no. Yeah, I got with the issue of GDPR EU lawsuit against AIQ. Looks like AIQ never paid the dollars for violating GDPR. Are there any laws that can further hold AIQ accountable to pay EU for violating GDPR? What if AIQ never complies? So it's a great point, right? It's the point we were trying to make. By them not having you, comply with the regulation out of your country and violating the rules with EU citizens, they have to rely on the privacy office of the local jurisdiction to find people accountable. Whether there's remuneration that goes back to the Treasury in the EU specifically to get paid for that infraction, I don't know that there, that's likely going to be a thing that happens, upcoming, because, different treasuries, holding different countries accountable is just it's a governance thing, right? It's a sovereignty thing. And I don't think Canada or the USA is necessarily going to cede, to the laws and practices outside of their country. They're going to say, we'll obey it when we're there. And that's kind of cultural observance, but it's not going to be something I think that'll happen overnight. I think that you also have an opportunity for the regulations in BC, which disappointed the Privacy Commissioner, who did want monetary remuneration in that case, to start changing. And so you see Quebec change their privacy regulation in the latest round to include up to $20 million US in fines, right? That's the fallout of things like this happening, is that when people want to fine, you can see them getting creative with, like in Castle's case, they got creative and tried to fine people for sending out malware to people. They gave them a Castle violation for sending them bad emails, which is a creative way to get the fine. You see the Federal Trade Commission and other trade commission saying this is anti-competitive. You're doing things without people's knowledge, and finding ways to make those creative regulations become part of the fine. But those wouldn't be necessarily ways that the EU is going to collect a check. That's different ways that the country can collect a check for those types of things. But the hard and fast rule, I think, that's going going to show up is that they're going to amend their privacy regulations. And you see it usually by population density, you get to amend it. So California and New York first, Quebec first, because there's 13 million people on the aggregate of 33 million in Canada that change their regulation to have those fines in them first. And that's, I think, how that's going to roll out. Okay, we got a bunch of other questions here. When should I contact a lawyer if I'm breached? If you're on the fence as to whether or not something's clear cut and the privacy office starts to come back or customers start to come back, you may find yourself in a position where you have to protect yourself from a legal perspective, right? There are, things that you want to set up as IT. Keep in mind, just like I said at the top of this call, I'm not a lawyer. This isn't legal advice. As an InfoSec officer, you're interpreting the regulations as they apply to IT. So you're interpreting, you're giving the lawyer the opportunity to say, here's the types of information we collect, here's how long we store it, here's why we have it, here's how, we're going to notify if something happens. But then when you start to set up communications potentially to the privacy office or to your customers or stakeholders, that's probably a good opportunity for legal to take a look at what specifically you're saying. So that breach notification letter may want to pass through a communications or internal in-house counsel to make sure that you're not putting yourself at undue risk with the language that you're using in those words. I had a company that had a ransomware attack, but they said no sensitive information was accessed. Should I take their word for it? If they're telling you about it, they believe you're at significant harm, right? They believe the information was accessed. They're letting you know about it. Typically, there's not going to be a lot of goodwill from most of these companies that are just saying, oh, we had some virus and we're going to tell you everything we know about it, right? They're not going to be overly verbose. They're typically going to be telling you as little as they can about something that happened to try to get you to understand that you probably have to take investigation or information yourself. They'll have briefing sessions. You're not likely going to get very good information out of there. They're usually protecting themselves, especially in a customer-client relationship, from losing the contract or undue, verbosity that puts them at greater risk. So if somebody says they had a ransomware attack and they're letting you know about it, it's good to assume that the information was lost and stolen. You're probably going to have to go through and let your companies know about that third party's breach. And this will be a perfect case study, I think, to talk about what happened in the Blackbot example in our next webinar. All right, guys. Well, we're a bit over time. Really appreciate those who asked questions, those who had things to say about us. Tune in next time. Make sure you grab the resources from us, the resource kit, the notification thing. We took a lot of time to put that together. We hope you can get some value out of it. IR guide, as well as the notification letter that helps us do that. All right. Thanks, everybody.